A very good evening and a warm welcome to our episode on Law and Order. And today we are going to focus on something which affects all of us in our day-to-day lives, and that is the family law of Sri Lanka, particularly the law affecting marriage and divorce. And we are more than happy to welcome today to our studio Mr. Ian Fernando, attorney at law. It's a pleasure to have you here,
Good
sir.
afternoon.
Good afternoon.
All the
sir.
best to you.
Sir, so my question is now, before we go on to the issue of marriage, today we see that a lot of people express that they are in love with another person on social media, on WhatsApp, or even through their behavior. So
On Facebook.
On Facebook particularly. And in law, we have a concept called promise to marry, where once you promise to marry someone, that creates certain obligations and you would be bound to compensate if the promise is breached. And my question to you, sir, is now if a person expresses that he is in a love affair with another individual on social media, would that amount to promise to marry? Or if a person, if a couple expresses that they are together to society by going to parties together or by visiting places together, would that amount to a promise to marry? What is the law behind this?
If you are seen out generally in public in Sri Lanka, if you are going out with someone and you are seen regularly, the social elite will try to say that you are going out with her and therefore that there is an affair between you and her.
Even if there is not.
Even if there is not. However, in Sri Lanka, and normally the law of the country is that once you promise to marry a person, you should state a date on which you are promising to marry the person. Otherwise, the mere fact that you are seen in any social gathering, any dance or any nightclub or any party or seen shopping together doesn't amount, or writing on Facebook and WhatsApp doesn't amount to be a relationship that will end up in a marriage. For a relationship to end up in a marriage, for a promise to marry, there must be a specific date that you will encounter and say, on or before this date, I am hoping to get married to you. And necessarily, if it's in writing, it will be a full-fledged promise. Unless you can prove verbally by a voice recording that you have given the date on which that you were promising to marry and you have failed to do so. In such a situation, either spouse has a right to file a case against you in the district court for damages for the inconvenience and the damage caused to that person's reputation and character.
And that is the law relating to promise to marry. And you mentioned that even a voice recording would count as valid evidence. Is it?
As our law has advanced under the new evidence ordinance, the Special Provisions Act, which says that contemporaneous recordings are taken into consideration. Those are the days, gone are the days that you wrote love letters and specifically mentioned about your love. On your phone recording or on a voice recording, if you have explicitly mentioned that you want to marry this person and you must set out a date, that is very important to say that you are going to marry, and if it's recorded under our provisions of the law, it can be construed to be a valid promise, and if it's breached, you can be sued in damages.
So that is with regard to a promise to marry, that is prior to a marriage. And now when we talk about the marriage law in Sri Lanka, now we all are familiar with the process of having a wedding and registering it. But there are also people who do not wish to register a marriage. So so that brings the issue, is registration a must in order for there to be a valid marriage, or can you get married without registering?
Under our general marriages ordinance, a marriage can be registered and a marriage can be made out by habit and repute. The words habit and repute is, like I mentioned earlier, if you are seen out together for a considerable period of time and you are living in the same house together for a considerable period of time as husband and wife, then it could be construed to be that you have had a marriage of habit and repute. So the public would say that by the reputation that you have earned by living together with this person in this particular place for so long, you are deemed to be married. So to have a valid marriage, registration is not a must, but you can prove that there has been a marriage de facto by you living together with that same person in the same house. Those are the provisions that apply.
So, so even if a person has not registered the marriage, still the valid consequences or the obligations of marriage would arise if you live together. But in Sri Lanka, there is a tendency, because Sri Lanka is very interwoven with culture and tradition, that certain people only perform religious rites when it comes to marriages. The Porva ceremony or a church wedding is all what is done to formalize a marriage. Would that amount to a marriage? And if a person is claiming that a church wedding or a ceremony at the Kovil is a marriage, how does one prove it in courts?
The ceremony of a Kovil or a marriage registration in a Roman Catholic church, not the registration, normally Roman Catholic church there is always a registration. Those are not considered to be a marriage until you sign the marriage register before the registrar. Those are only celebrity facts. You are having a wedding afterwards, so you are having a religious ceremony, doesn't amount to a marriage. The marriage proper is when both parties enter into a contract. That is why you see when they enter into this famous contract called marriage, they get all the best people whom they know to sign as attesting witnesses, the president, the prime minister or whoever, all big people of their name, to be witness to the wedding. That is the contract. The other matters are only incidental matters.
All right, sir. And then we have performed a marriage, and then a marriage goes on. There is also legal provisions with regard to divorce. And getting a divorce is not as easy as getting a marriage, because you will have to go to courts for that, sir. On what grounds can a person get a divorce in Sri Lanka?
There are mainly three grounds in our law. In South African law, they have gone a little further. The three grounds in our law is that you have maliciously deserted your partner. The other one is that you have committed adultery. That's whilst being married, as a married person, you have had sexual intercourse with someone else. And the third is incurable impotency. Under South African law, they have gone to the extent of saying that if the parties are not living together for a considerable period of time, which they have specified like 2 years, then you can apply for divorce. Also, if one of the spouses are mentally incapacitated, that she has a mental or he has a mental sickness that cannot be cured, also there has been the right for divorce. Also, it is seen at that time in South African law, if you had gone to prison for a long time and the marriage cannot be performed for a considerable period of time, I would say over 10 years, then there again you have a right to get your divorce. Those were the instances in which divorce can be applied to.
And also, I think a very controversial issue when it comes to divorce is the issue of adultery, because different people might have different interpretations to what constitutes adultery. And in law, what is adultery, and what does it take to prove adultery in courts?
Actually, in fact and in truth, that is the most difficult ingredients to prove in a divorce case.
Out of all three, these are the most difficult.
All three. In fact, as a practitioner, I would certainly endorse that this is the most difficult fact to prove. There can be circumstantial evidence of one talking with another on the telephone, one sending SMS, one sending notes, one meeting regularly. But to prove adultery, you have to have the ingredients that both parties were in sexual intercourse at a particular place with date and the place address. So, for example, if you can prove that in a hotel they were in that particular room on this date with another party, a married person, that amounts to adultery. Just for the fact of being seen together doesn't amount to adultery. And as far back as 4 New Law Report, page 106, as far back as that's somewhere in 1904, courts have decided that if you want to prove adultery, you must state the date and place of adultery. Many of us, when we are practicing in our plaint, the date and place of adultery is not there. Then that is the grounds for the opposing counsel to take objection that you cannot construe this as adultery and to get that particular issue in the case struck off. And furthermore, to prove adultery, though adultery is not even a charge in the penal code, there are so many offences in the penal code like theft, murder, robbery. To have a charge on adultery is not there even in the penal code. The adultery charge, however, is a charge between two parties, the husband and the wife or vice versa, and that has to be proved beyond reasonable doubt. In a civil case, the possibility of proving is only you have to prove 51%. Criminal case, you have to do it 100%. So like in a criminal case, this is the only situation in a civil case, in a civil forum, if you are proving adultery, you have to prove it at 100% possibility.
And also with regard to the issue of adultery as a ground for divorce, now there have been different situations where different persons have alleged that their spouse is having another affair with another person, and sometimes they have obtained photographs of them having dinner together or going out on parties together, and they rely on these photographs or SMSs as adultery. How effective is that?
You cannot prove adultery, but you can prove that there must be a nexus or some closeness between the two parties. That is all that you can get to.
And that you will not get a divorce?
You will never get a divorce on those grounds. Your picture, or you have been closely associating that person, or in a public place you have been closely dancing with that person, will only associate that you have a friendship with that person, nothing more. You cannot construe that to be adultery. To have adultery, you must be in one room, two people, one of which would be married or both may be married, and they should be performing the rituals of marriage.
And also when it comes to the second requirement, or the second instance where one can rely on to get a divorce, and that is malicious desertion. What exactly is malicious desertion? We are aware of the word of desertion.
The word desertion counts that you are deserted by your spouse. Malicious desertion means that you are deserted maliciously. For examples, you may think that you have to leave the particular house to desert either spouse, and that can be construed to be malicious desertion. That is not the contention. If you are living separately, bed and board, those are the two words, even in the same house, in two different rooms, and you are not performing the marriageable responsibilities that you should be performing, that is a clear case of malicious desertion. For example, if one spouse doesn't do the matrimonial duties of looking after the other spouse, of looking after the normal contents in a marriage, whomever it may be, whether it's the lady or whether it's a gent, and you're still living in the same house, that is supposed to be you have maliciously deserted your wife. And in our law, it is said that after a period of time, that there is a separation between the parties due to this fact, and a time period construed by court, you may be able to get, on the grounds of living separately for so long, a divorce in your favor, whoever who has been the party who has been suffering from this guilt of the other party.
So simply giving up on your responsibilities would amount to malicious desertion.
Correct. For example, your matrimonial duties that you have to perform, if they are not performed, the other spouse can turn around and say, I am living in separation, and the other spouse is not doing anything to bring back the marriage to its normal routine situation that it should be.
And we also have a situation where you compel the other party to leave the matrimonial
Yes,
house.
that is, you make life intolerable to make the other party leave the particular matrimonial house. In my era of practicing, I have noticed that sometimes the other spouse will deliberately do that to get you out of the house, do certain acts, make complaints against you at police stations, make gestures about you to the others to make you feel uncomfortable, and to complain to many others about you in public. Those are facts that that person does in order to get the other person out of the marriage. So, vice versa, if the other spouse also does the same thing by making it difficult for the spouse to stay at home, then it's constructive malicious desertion. In Roman law, it's called animus revertendi. Those are the words used. So, you make life impossible. For examples, you do not greet the spouse, you do not provide the basic amenities that the spouse would need, you will not look into the interest of the spouse, and will defame the spouse at home and make it uncomfortable for the spouse to stay at home. Then you are guilty of the word constructive malicious desertion.
And also, sir, now moving on to the third ground for divorce, incurable impotency. Now, in your life as a practitioner, I mean, out of all three, what would be the most easy way to get a divorce?
Malicious desertion is always easy, but it's always coupled sometimes with adultery, very rarely coupled with impotency. Sexual impotency has to be incurable.
And
so,
could you be able to explain more on the issue of incurable impotency?
Yes, in today's context where we are the advancement of science, I think the impotency levels can be checked via your tablets that you take. But there are situations where there's incurable impotency. Even injections won't help you. I know certain people. So, you then have to get a certificate from a doctor where you are medically examined, and to prove to court through that doctor that your impotency is incurable. You cannot construe a person at a very old age to be potent at 70 and ask for incurable impotency. In a reasonable man below 70, if you cannot perform the matrimonial obligations due to an illness which is incurable, that would amount to sexual impotency, which is incurable.
And also, now when we talk about the divorce law in Sri Lanka, with your wealth of experience from being a practitioner for many decades, I would say, what is your take on the divorce? Because Sri Lanka is one of the countries which has a very high rate of divorce when we compare with other countries. What is the main reason for divorce in Sri Lanka, and out of the three grounds, what do people rely on the most?
In my 3 decades which I have practiced as a lawyer, I find that the 3 grounds are the grounds set out by law, but there are other mitigating factors that come in to play, such as due to a third party's influence on the marriage, the breakdown of a marriage due to finances, and also the colloquial thing that everyone says, the mother-in-law's influence. Those are things that I have seen, but mainly with all those influences, if the 2 parties still stand together, I have seen situations in my 30 years where they have moved out from their parental house and the marriage has worked out very successfully. As so long as they have been living in the parents' house, it has been a flop. So, in our culture, it's normally a bit different than the European sector. So, living with the parents is normal, but it's not always the good thing for a newly married couple.
And also, is there a reason why Sri Lanka has very high divorce rates? In a very open-ended question.
We are a fast developing country, and I think due to that fact, the idealism of what you should be as a man or a woman changes overnight. Fashion, design, the way you talk, the latest trends. So if you find out that your partner is not keeping up to that, or you disagree on certain matters, the disagreement is the cause which starts the rift. So long as one party will beg not to disagree, then the marriage will go on. So in our culture, which is of late a fast developing culture, there are so many different aspects that society is developing sociology, on the sociology side. So you would see major changes taking place, whereas those days divorce was an unheard of matter, and it was a taboo word to be used in society. Today that word comes off the lips at every turn from either spouse.
And also, sir, my final question before we wind up today's episode. Now, if a couple is there who have come into an agreement that they want to terminate the marriage, and both spouses are equally thinking that this marriage cannot go on for long because of many reasons, maybe their likings are not matching, or it was an arranged marriage against their will. So if it's such a situation where a couple wants to amicably get a divorce, what is the remedy available in Sri Lanka?
There is a remedy where you can file the divorce papers, and there is a particular provision in our law where you can, the other party, after the filing the plaint, can just send in a note signed agreeing the facts of the plaint and get the divorce. I would say not instantly, but at least within 3 months, because then both parties have agreed. Even the party who has to file the answer is not filing the answer to the plaint, they are filing a statement setting out there is provision in the Civil Procedure Code to say that he is in agreement with the facts in the plaint, and the divorce can be granted. But in doing so, I have seen practically that it is the adjustment on properties that both parties are trying to gain before they enter into a divorce settlement of this nature. That is, either party is not sure when that party goes to court what the court will determine and who would be the guilty party who has to pay the other party. There is a big ambiguity there as to who will win the case. So therefore, to take the safer side and the safer line and the quick method, parties agree to divide their properties and call it a day. But I have also seen circumstances in which wives have brought property in the husband's name, and the husband has had half share of his property, where the wife also has the half share, and now at the point of turn or divorce, the husband clings on to his half share. That half share has been brought on the position of trust, and with the principle in law on the advancement of trust, if the wife has brought that property to the husband as a gift, it's difficult to get back. If the wife has brought that property with the contemplation that after her death it should go to the husband, it cannot be got back. Difficult. The burden is great. But however, if nominally as a trust she has given her title deeds and given her properties to the husband to keep it as long as the marriage is going on, then there is a lot of scope where the property can be asked back for. And in divorce settlements, we see that regularly happening.
All right, so thank you. And now as we wind up, we would like to thank on behalf of Channel Live for sharing your experience and wealth of knowledge on the issues of marriage and divorce in Sri Lanka, for particularly sharing a very practical aspect on how these issues are actually practiced in society. So thank you so much, sir, for taking time off your busy schedule for being it here at Sri
My
Lanka
pleasure.
Rupavahini Corporation. And once again, we would meet you in another very useful and fruitful discussion on law and order next week at the very same time.
Thank you.